Good morning.
Good morning. May it please the court, my name is Martha Dinwiddie from the Knoxville Bar, here for the appellant Todd Lee White. I would like to reserve 3 minutes for rebuttal, please.
Certainly.
This court should reverse Mr. White's conviction for felon in possession because of the erroneous admission of cell phone data from his phone, and this error was not harmless. By way of a little bit of factual summary, so Mr. White pled guilty to possession of marijuana with intent to sell in 2013. A violation of probation was issued in 2016 that just remained pending until basically this incident in 2022. Officers with the sheriff's office in Knox County received an anonymous tip that Mr. White was an absconded felon that was selling drugs and had a phone and had a firearm. And because they had that outstanding warrant, they went to his trailer where they basically went in, they arrest him, they see what they believe to be marijuana in plain view. They went to the neighbor, Ms. Tanya Russell, who was Mr. White's landlord, and asked if she knew anything about any firearms because of that anonymous tip that they had received. And she said, I believe it was that he had told her that the night prior that he was going to be shooting a gun in his backyard, and she told them to look beneath the floorboards. Just so the court is clear, neither Ms. Russell's statements nor that anonymous tip were admitted at trial, but they were included in the search warrant. So the officers go back to the trailer. They find basically there's a hole in the closet, and sort of not directly underneath it, but beneath it, there is a firearm and 3 magazines. They go outside of the trailer and use, I think the testimony was a stick or a rake to remove those from underneath the trailer. A cell phone was found next to the bed near where Mr. White was arrested, and approximately 2 weeks later, I believe, Detective Pickett got a search warrant for that cell phone. And that search warrant is sort of the threshold issue here. That search warrant pretty much just put what I just said in there, and the only reference to Mr. White's cell phone in particular is that it was found on the floor. There's nothing that indicates that Detective Pickett knew that Mr. White used that cell phone in order to sell drugs, to communicate with potential buyers.
Let me ask you first, did he even need a warrant?
I believe that he did.
This is a probationer.
Yes.
Probationers sign away a lot of their rights as far as searches are concerned, and one of them is the right to search property. This is his property. Why do they need a warrant?
So I think that that's a sort of multi-layered question. I think first, there is a statute, it's section 40-6110, that lays out that law enforcement is not allowed to search a person's cell phone unless they have a search warrant, they have informed consent, or there's exigent circumstances. And because
why wouldn't a probationer signing away their rights, so to speak, in order to get probation, not informed consent?
Well, I think first, there's not a statutory definition of informed consent for the purposes of that statute. I think that the parties are sort of in agreement that the Black's Law definition would apply, and informed consent requires a person to agree to something, being aware of the risks and the alternatives. So I think that informed consent is broader than constitutional consent, first of all, because courts have continuously found that constitutional consent, in order to be voluntary, doesn't require that the defendant know that they're not allowed to, or that they're allowed to say no. So they don't have to know the alternatives under constitutional consent. So I think it's broader than that. And in addition, I think, Mr. White signed this in 2013. We don't know if he had a cell phone at the time. He certainly didn't have probably the technology that was then available in 2022. I think that to say that that was informed consent at that time to search the cell phone data there's such a large gap in time there that I don't think that we have really proof of that. And in addition, I think that it is not clear that the data on the cell phone is itself property that Mr. White has exclusive dominion over. It's more the federal courts that have been grappling with these issues than our state courts. But federal courts some of them have started to be considering the actual cell phone separately from the data within it. And so I think that that's because the data is not necessarily property. I think that adds another layer to it. Additionally, I think under sort of the constitutional jurisprudence, regarding searches of probationers, the basis for the ability to conduct a warrantless search of a probationer is not consent. So I think that that's one thing that I was not as clear about in my principal brief, but I think I attempted to clarify in my reply. The basis for searching a probationer is not consent. It's that the probationer has a reduced expectation of privacy by virtue of being on probation. And when you balance that with the state's interest in reducing recidivism and basically making sure that probationers are not committing new crimes, then we have said that it is reasonable to search probationers. I think in State v. Ham, Justice Clark's dissent, she refers to that as a special interest search, which is she gets from Griffin v. Wisconsin. So it's not a consent search. So I think that Mr. White has not, for various reasons, yes, to answer your original question, I do think that Detective Pickett needed a warrant. And that is, and I'll go back to the warrant conversation a little bit and say that the only additional things that Detective Pickett included in that warrant, besides that Mr. White there was a phone next to the bed, was that in his training and experience.
Well, it's more than just a phone next to a bed. It's a phone in a room that's full of drugs, scales, bags, all these. It's not just a phone that happens to be in a room that, there may have been, an ounce of marijuana in. I mean, there's more in the room than just,
Sure.
The room gives across the impression, as I understand the record, this is someone who's not just casually, recreationally using drugs. This is someone who's selling drugs.
So I think that it's very important to distinguish whether there is probable cause to believe that Mr. White is selling marijuana.
But I understand where you're going, but do you agree with me that the room is more than just someone who's recreationally using drugs?
I think under this factual scenario, there is probable cause to believe that he was possessing that with intent.
And the officer's affidavit says that in his experience, in dealing with this type and this amount, that these dealers or sellers use their phone to communicate and conduct their business.
So that's actually not what Detective Pickett says in his affidavit. He doesn't ever say that in his experience, drug dealers use their phones to communicate with buyers and sellers. He says that drug dealers keep telephone numbers and addresses of associates and customers, that they might keep photos of their associates or their products on their phones, that drug dealers often have passcodes on their phones, that they'll need to search the phone off-site, and drug dealers often have multiple phones. So there's nothing in the search warrant affidavit's text itself that even says that drug dealers communicate using their cell phones.
Well, if it says they keep numbers or names of their customers, what else do they use? They're using the phone to sell the drugs in some form or fashion. They may call from a different phone, but I've got everybody's phone number in this phone.
Well, I think that's a potential inference, but when we're talking about a search warrant, we have to go within the four corners of the document. And so if Detective Pickett meant to imply that, then he could have spelled that out quite easily. And so, there's the other issue is that I think it's a little broad to say drug dealers use their phones to communicate with customers. Well, how do they do that? And how would an extraction of that phone yield that information? Because there's a lot of different applications that drug dealers could potentially use to be communicating, and some of that will not be shown in an extraction. So I think that given the sort of multiple avenues that a drug dealer could use to communicate with people, I think they do need to go above and beyond and say what they mean.
I'm looking at the search warrant. He's got 5 separate subparts about how in his training and experience cell phones are used in drug dealing and drug trafficking.
Well, one of those subparts is that cell phones have passcodes. Another one of them is that they'll have to search the phone off-site. I don't think that those are really particularly related to drug dealers at all. I think that when you look at what is actually, and then the other one is
Well, 3 of the 5 are specifically about how drug dealers use cell phones.
Well, one of them is also that they have multiple phones, and we don't have any evidence of that in this case. So I think really that leaves 2 that are pretty sparse.
Well, there's multiple they often use multiple cell phones and change phones in an effort to avoid detention and identification. So, I mean, I read that as this could be one of those phones.
Sure, I think he could have been a little more explicit about what he meant by that, because that's not necessarily what I took from that. I kind of took, well, this was a copy and paste job from another warrant. I didn't see how that was related to this case. So I think that really what this ultimately comes down to is that there's nothing in this particular warrant that differentiates Mr. White's phone or these factual circumstances from anybody where the officers have probable cause to believe that they've committed a drug offense of possession with intent to sell. And when it comes down to it, if the Fourth Amendment particularity requirement is to mean anything, I think that they need to be specific as to why this particular phone, we believe, is going to have evidence of drug dealing on it. Otherwise, it's pretty much a general warrant, right? We have probable cause to believe that that you're possessing this with intent to sell. Drug dealers use phones. You've got a phone, so then we get to search your phone. And I think the Fourth Amendment requires more than that. If the court doesn't have any other questions about the search warrant in particular, I would like to just make a couple of clarifying points, I think, about the probation issue. And so if this court is to find that the search warrant is insufficient, then we have to grapple with the issue about Mr. White being on probation. And so I've already discussed a little bit that statute, TCA 40-60-110. There's not a lot of case law construing that, but I think that this court could resolve this issue without even having to really touch the probation issue, because I think that statute, the constitutional probation issue, that is, because I think the statute can resolve it, because it's quite broad. The legislature was clearly saying, under these circumstances, we believe, or these are the only times that law enforcement are allowed to search cell phones. And I think in the state's brief, they had said that, well, the legislature isn't required to set out exceptions or subsets of consent, and so this isn't an expressio unius situation. But I think when you look at the case law and when you look at really what the reasoning for a probation search is, it's clear that it is not a consent search. And so the legislature does not have to set out subsets within consent, but a probation search is not a subset of consent. And so it doesn't fall within any of those three enumerated categories, and therefore law enforcement has to have a warrant to search the phone. The other issue is then, under the constitutional issue, whether probationers, basically whether it is reasonable to search a probationer's phone without a warrant. And I think that under the emerging case law regarding cell phones and this sort of technology, it is not reasonable. And so this court has to, again, balance the state's interests with the probationer's interests. But part of that balance considers the object of the search. And the object of the search, being a cell phone, is very important. And we can't ignore that. We can't just mechanically apply prior precedent and just say, well, we've upheld this in other circumstances, and so it doesn't matter that it's a cell phone. Because the United States Supreme Court has made it clear that when the subject of a search is a cell phone, we aren't going to just mechanically apply those prior precedents. So when you look at Riley versus California, that was a search incident to a lawful arrest. And ordinarily, under the prior case law, if you've got basically property, a container on your person, then law enforcement can search it as a search incident to arrest. And in Riley, they recognized that an arrestee has a reduced expectation of privacy versus somebody that's just kind of walking down the street. And so I think that given that Riley considered sort of an analogous situation where we have somebody with a reduced expectation of privacy and said, nonetheless, But
the probationer's expectation of privacy is even less, would it not be, than someone who's been arrested?
I'm not sure whether anybody has squarely addressed that issue.
I mean, because the probationer's actually been convicted of a crime.
Right.
Someone who's arrested, while their expectation may be lessened, they still have, the presumption of innocence, and all those types of things that go with it. once you're convicted, I mean, the law's pretty clear. Once you're convicted, your expectation and your rights are diminished greatly based on that conviction, especially a probationer. And so let's change it from a drug dealing case. What if he was a child sex offender and we don't allow them to have social media and those types of things? I mean, do you think that they really have to get a warrant to search his phone to see if he's got an Instagram account, a Twitter account, or whatever? Because, I mean, that's truly one of the concerns they would have, right? And then that's where a lot of them get in trouble, is because they have secret accounts on their phones.
I think I would differentiate that because of the sex offender registry. I think that's a sort of added layer where you've had a more specific agreement that you are going to submit to searches, that you're not going to make those accounts. And so in order to sort of affect the purposes of
Why is that different from an officer testifying that drug traffickers use their cell phones to run their business? This is how they keep in touch with people. This is how they keep in touch, or this is how they manage their product, for lack of a better way of saying it, when you said take pictures of it or whatever. And I found this phone in a room that screams drug trafficking. How is that any different?
Well, I think ultimately, because this is a Fourth Amendment issue, you have to look at it on a case-by-case basis. And so, not to dodge your question, but it obviously depends on the circumstances and the totality of those circumstances. But I think that, you've got different rules that apply to sex offenders because of the sex offender registry than just a probationer. And so I'd say they probably have a further reduced expectation of privacy, sort of by virtue of what they've agreed to by being on the sex offender registry, or the conditions that have been imposed.
So that's what, but using that analogy, why Riley does not say this is a blanket no search of cell phones without a warrant. It doesn't say that. It clearly creates a different area, but it's also different from an arrestee and someone who's been convicted. You got to see that there's a different expectation of privacy level between those two groups.
Well,
just like you say there's a different expectation of privacy between a sex offender and a regular probationer.
I think the problem I think that I'm having with the arrestee is that I'm envisioning what happens after they're arrested and they go to the jail and they could be strip searched, or they can be subject to a large invasion of their privacy, and once they're in custody, they don't have an expectation of privacy. So I think that I'm getting a little hung up on that part of that. But I do think that Riley, while it is considering a more narrow factual circumstance, there's some very broad language in there that says, not that you're not allowed to search a cell phone, but you've got to get a warrant before you do. I see that I am not over my time yet. This is my first time doing this, so I'm still getting used to the lights. So I was ready to finish my thought there and finish answering your question, but now I've lost my train of thought, so I will yield the rest of my time to rebuttal.
All right, good morning, General.
Good morning. May it please the court, Liz Evan on behalf of the state. I want to discuss, first of all, the purpose of the exclusionary rule, because I think that will help inform this court's decision here. And repeatedly, the purpose of the exclusionary rule is to prevent police misconduct. And so when we look at all these different issues related to this particular search, we've got probationer's consent, we've got a very detailed 4-page single-spaced affidavit with very particular places to be searched in the phone. There's just no indication here that there is any kind of police misconduct. So with that said, I would like to discuss the fact that this is a consent search. And I think that
Let me stop you
Sure.
too far into it, because I know I gave your counterpart a difficult time about a probationer and their rights and consent search. The trial court even make that finding, though?
It did not.
So should I really even be bothering you with those questions? I mean,
Well-
the trial court didn't make a finding. What are we really reviewing on that then?
Well, Your Honor, we are on the de novo review here, and it can be considered, the detective testified at the suppression hearing about the probationer status. He testified that he knew he was a probationer subject to a search at any time, that he had discussed this with the probation officer ahead of time. So there are facts in the record establishing that this is a consideration. Just because the trial court didn't need to rule on this issue because it found that the affidavit was sufficient, but it's still a legal issue, and another reason that this court can affirm.
I mean, if you ask me, the trial court dodged the question, and I'm jokingly saying that because it's now our colleague. But
Exactly.
I think he
Far be it
dodged the
from me.
opportunity to address this, but that's fine, whatever.
Right. Well, and so I want to discuss State v. Ham because I think there's a little bit of confusion here about consent versus reduced expectation of privacy, and they're intertwined, right? The touchstone of the Fourth Amendment is reasonableness. And so in the context of a consent, we've got a probationer's consent, which our Tennessee Supreme Court said in Ham is a waiver of the Fourth Amendment right. And to do that, they cited a Sixth Circuit opinion, Tessier, where the Sixth Circuit explicitly reviewed the Tennessee probation conditions language and said that's a waiver of a Fourth Amendment right. And that waiver reduces the expectation of privacy, which then results in these limited guardrails that our Supreme Court handed down in Ham. And those are the law enforcement must know the probationer's status. The probationer signed the conditions of probation, indicating they were aware of the conditions of probation, and the search was conducted pursuant to a legitimate law enforcement purpose. And all three of those are easily met here. And another panel of this court applied this Ham to an almost identical situation in March of '24 in State v. Quinn, and said that Ham is what controls here. I do cite this in my brief. State v. Quinn, Quinn, that there the defendant challenged the search as unlawful, the search of his cell phone. The trial court denied the motion to suppress, and this court affirmed the trial court's decision, stating that that search of the cell phone, because he was a probationer, satisfied Ham. And so even though that's unpublished and just persuasive authority, we would ask this court to apply the same reasoning in this case.
How do you respond, though, to defense counsel's argument that there is a difference between consent to search my property, being my house, my car, my garage, whatever, and consent to search a cell phone? That those are different kinds of property. There's a lot of stuff on the cell phone that could be on a cell phone, which I don't really own. It's not really mine. It's kind of how they laid out the argument. And so I haven't really consented to allow you to search something I don't really possess, but you're doing it anyway. Whereas my car, my house, my room, that's clearly mine, and I've clearly consented as a probationer. Do you see a difference between those two?
I think that distinction did come in Riley v. California, but it was so explicitly limited. I mean, the Supreme Court limited that reasoning to the search incident to arrest, and that's at Penn Site 402 in that case. And so, although in our situation, now my friend on the other side does cite to this Ninth Circuit case, which interprets California's language, which is significantly different from the language here, and in my opinion, the Ninth Circuit may have gotten that wrong. But anyway, the language there talked about property including, and it listed then different kinds of physical property. And here we have property, which is very broad, person, vehicle, or residence. There's no limitation here on what kind of property can be searched when someone's consenting under the probation consent. And even if this court finds that the defendant did not consent through probation consent, the affidavit had sufficient specificity and nexus. And my friend on the other side is correct. This is a totality of the circumstances review. And here we have in the affidavit that the defendant had a significant violent criminal history. He was on probation. Law enforcement went to serve a probation violation warrant specifically for selling drugs. The law enforcement first went to the property's main residence, which was the landlord's home. And this landlord said that the defendant would regularly shoot his gun outside and told the law enforcement exactly where to look for the gun through the floor and the vents. The law enforcement went to the trailer, knocked and announced their presence, and they heard footsteps inside, so they forced entry. And they saw the defendant standing in his bedroom with his belt undone, baggies of marijuana on the dresser, his phone next to the bed, and the gun in the floor of the closet, underneath the floor of the closet on the ground. The gun was dry, warm, and clean, even though it was a cool, humid morning. And underneath the ground there, underneath is obviously dirt. So they had every reason to believe that he had just possessed the gun. The warrant is based on his drug sales, though, obviously, and as Judge Ayers noted, oh, sorry, I thought you were asking a question. As Judge Ayers noted, it specifically said drug dealers commonly maintain these contact information for associates or customers in the drug trafficking organization. And if that doesn't relate to sales of drugs, I don't know what would. And then also that they possess photographs of themselves, their associates, their property, their drugs. These things in and of themselves, along with the fact that it was found in the same room with the defendant, with the gun, with all of these drugs, the totality of the circumstances, I would agree with Judge Sword in his decision, even if he sidestepped the consent issue, that this was sufficient. I think that I have addressed all the points I wanted to address, so unless the court has any particular questions, we would ask that you affirm the trial court.
Thank you, General.
Just briefly clarifying the record, I don't know if this was a misstatement, but Detective Pickett did not testify at the suppression hearing. There was no testimony from him, so the court was relying solely on the affidavit for the search warrant rather than any testimony about consent or anything like that.
What more should have been in the affidavit? I mean, what more can you say about a cell phone other than it was there in this room with all these drugs and all these other indicia of drug trafficking, drug trade?
I think you need something that gives rise to probable cause to believe that there is that information on this particular person's phone, such as information about him using the phone to sell drugs, or even, information about seeing him use the phone. There's nothing even saying that he used that phone in the search warrant. And so we've got like a 2-week period between when Mr. White gets arrested and when the search warrant is executed or when he gets the search warrant for the cell phone. And so he could have done some background investigation if he really wanted to get into the cell phone. There were opportunities.
So you're saying for a search, for a warrant to be valid to search the phone, it's got to have specific information about someone having observed the defendant using the phone and...
As an example, I don't think that's a hard and fast rule.
It's going to be pretty hard for somebody to have that type of information,
Well,
unless they've been surveilling this person for a long
which
time.
they routinely do, and they might have a confidential informant or something like that. But I think it bears emphasizing that the question is not, do we have probable cause to believe that Mr. White was possessing that with the intent to sell? It's, do we have probable cause to believe that evidence of that would be found on his phone? And we can't just go off of what we know about other people to make that determination. We've got to relate it to Mr. White and his cell phone. I wanted to briefly respond to the mention of State v. Quinn. I think that with due respect to the lawyer in that case, their analysis was quite brief. They did not make any mention of TCA 46110, and really the reference to Riley was pretty cursory, and in this court's opinion, no mention of Riley was made. So I don't think that that is necessarily controlling because it frankly just wasn't developed enough. So I wanted to make sure that that was mentioned. I also wanted to just clarify, while State v. Ham does make reference to that Tessier Sixth Circuit case, it does not find that there is a waiver of the Fourth Amendment right, and I think that is an important distinction, because if it was a waiver, then there'd be no ability to challenge a search of a probationer, and that's just not the case, and Ham makes that clear, and there would be no need to engage in that balancing test if it was a waiver. I'm about out of time, so if there's no more questions, then thank you very much.
All right, thank you. The, excuse me, the briefs were very well written in this case by both sides, and arguments were well done that very helpful to us to make a good decision. So we'll take it under advisement. Let's take a 5-minute break, Mr. Clerk, and then we'll come back. We got 2 more cases. We'll get to those.
All rise.